Yeah, I think we are online now. Yeah. First of all, thank you very much for you participants of the 40th International Congress of the Brazilian Association of Intellectual Property to be here with us, you know, in this table topic 12, and where we are going to address or share some thoughts and understandings about fake news on commerce or fake news on trade. And in a sense, attempt to address one very specific question, you know, which is, are the legal deficiencies in legal matters and legal deficiencies to address fake news on trade in the international market? This is our main task over here. Yeah, we know that we have the Paris Convention that addresses unfair competition, disparaging products and traders. But I think fake news, you know, receives a more, at least should receive a more adequate treatment in view of the fact that all the information that put on the digital platform, you know, it moves quicker, and also the good point is that it sells quicker, but it damages quicker and faster. And this is the danger, you know, and so for us, it's important to address this matter, you know, and for this table topic, I have invited 4 participants, you know, and it's Irene from the US, Philip from Germany, Mei Li from China, and Raul Murad from Brazil. We don't have much time, you know, and in fact, I want to thank all the speakers about joining us over here. It's and also take the time to address a matter which is complex, you know, because it deals with several other issues, not only unfair competition, but also trademark violation and you know, and image infringement. So I want to thank you very much, and also to speak in such a short time frame, which is 20 minutes for each, you know. So I do not want to lose time. I want to go ahead, and then I'm going to pass the microphone to Irene Cowboy. But before, really quick here, and a short curriculum of Irene. So Irene is a professor of the School of Legal School of Texas, A&M University, you know, and she has published several books. Also, she's very active at the INTA. You know, we share a book. You know, I was honored to participate as an article on Brazil addressing trademarks, and I was invited by her. You know, she's very renowned, and also she deals a lot with fake news. So, Irene, you should start, please.
Many thanks, Jose Carlos. Many thanks to all the participants. May I confirm that you see my screen, my slides? Many thanks.
Yes.
I want to thank the Brazilian IP Association and apologize if I can't speak in Brazilian. I'm of course in Portuguese. I'm originally from Italy, so I can say buenas tardes, muito obrigado. But what we are going to talk about today in this table topics is one of the really hottest button, and something that I happen to be an American citizen, and you know the United States is going through a bit of an important time till 2 weeks from now, we have an election going on, we have a lot of news, a lot of fake news, a lot of news that we wish are fake news. But today in our panel, we will discuss the relevance of this topic in trade. And first of all, before I start to do my slideshow, I want to thank my research assistant, Mr. Harrison Davis, who has been working relentlessly to help me. We were on a bit of a tight schedule, and there is lots of things going on, and really Harrison has been absolutely fundamental for me to be able to be prepared for this presentation, and I want to acknowledge him and thank him. So when I brainstorm with Jose Carlos, and one of the things I ask him is, when you talk about, in addition to, of course, the hot topic, fake news and fact checking, debate, and so on, when we go back to the basic, when we go back to trade and advertising and fake news, it's really fake news, nothing but an old debate with a new name. And in many ways, an old debate in a new place, which is the misleading advertisement now brought into the online world, the digital world. And because of that, the relevance of it has been exponentially much more massive, intrusive. Misleading advertisement was already, my PhD dissertation was specifically on misleading advertisement and comparative advertisement and a comparison between the United States and the European system back in the early 90s. But to a large extent, when we look at fake news in trade, now we're looking at digital platform, and we're looking at secondary liability. We're looking at, in the US, we're looking at Section 230, the Decency Act. But in reality, we're really looking at an old debate, the misleading information in trade that is now far more pernicious because of the digital platforms. And, you know, fake news, it's about fake news in trade, as I said, is a very old debate. The United States were one of the very first country in regulating misleading advertisement. That goes down to the essence of a fair competition. Some of my fellow panelists will talk about unfair competition in other jurisdictions, and the title of this panel is very much about competencia desleal, so, you know, unfair competition. And so when we say fake news, are we really saying misleading advertisement? And we know that misleading advertisement can be on two types. I can be the owner or the trademark owner or the company who tries to sell feature of my products that don't exist. So I'm the one saying misleading information about my own product. Or I might be the one saying misleading information about the competitor's product, about a third-party products. And so try to harm competition by denigrating or saying bad things about my competitors. Or saying fake things, false things about myself, again, with the same intent, trying to steer consumers to me versus my competitors. And in the United States, advertising law is regulated at the federal level by the Federal Trade Commission. There are the state level, state analogs. And really the object of protection, the subject matter of protection is competition, so competitors, consumers, we have Consumer Protection Act as well, but misleading, so the essence of the information have to be truthful, otherwise consumer will be led into believing information that are not true. And of course, you know, in intellectual property, also other parties, not necessarily just competitors, but other right holders. But the definition of advertising per se includes a persuasive aspect. It's not just information in advertisement, it's persuasion. And as we know, there is a lot of money that goes into marketing. And so this idea that advertisement is only about information to consumers, this is the debate in trademark law. It's that a persuasion or an information tool, and in reality is both. And so because advertisement has this double purpose, you want to inform and persuade at the same time, it's very easy to have an exaggeration in the information, or some truth or some information that is said in a way that is easily manipulated. And that's why marketing, subliminal, and all the psychology that goes into advertising works, is because information are not necessarily true, or they are true, but they are relatively true, and there is a lot of unwritten part of cognitive science at work with our brain and make us choose products. Why do we like the background that is pink or purple versus yellow or green, and why do we pick products of a certain type? And so, when we have this dichotomy in advertisement per se, the whole debate is really how truthful and how informative advertisement and so news should be. So news in trade are about selling products. How truth should they be or not? And in the United States, I would say, in Brazil now you have a pending bill, but in the United States, a lot of this debate across the world too, but I would say the US has this idea of First Amendment, freedom of expression, that is down to the core of society. My right to say what I want, even if it's false, in the middle of the street, I should be able to say it. And my right, even to say the false, goes against your right to be informed of the truth. To a large extent, some of this debate might sound a bit surreal to those who are not used to the principle, but the real core of the freedom of expression is we don't want to allow censorship. And so it's less dangerous for society to have false information than have censorship. Because if you allow censorship, then everything can be false, because no information can ever be 100% truth or objective. And really that debate is the essence, the building block of a lot of these debate on fake news now. But as we said before, the potential damages and the exponential impact because of the medium has become a bit out of control. And certainly, again, I think this is an old debate, but in a new place. And the new place is the online media, the online platform, the online marketplaces. And because the online marketplaces have become the window through which we talk, I'm sure now Zoom is perhaps collecting information, there is privacy, but then there might be advertisements and so on and so forth. And so we know the importance of technology in everything we do today. But this idea of online intermediaries is really what has enhanced the issue and the problems related to fake news. In the United States, we have had in the past few years a lot of discussion, even more so in the past years, in the past 4 years in particular, but I would say for a while, about Section 230, which is one of the additions that was introduced in 1996 in one of the Consumer Decency Act. And why? Is because, as the Supreme Court of the US has said, online providers are really the modern public squares. Now COVID has blocked us at home. We shop online, we do everything online, we order online. If I'm in China, I use Didi, or I use Baidu, or I use Alibaba. If I'm in the US, I use Amazon or Lyft, and so on and so forth. But our whole economy was very much on the platform, and now it's online even more. And certainly these 19th century railroad, such as Amazon or Alibaba, are major players in this debate. In the United States, we had Congress calling and summoning Zuckerberg of Facebook, Amazon, and many others just recently to discuss the liability of the big marketplaces and intermediaries. And they have a lot of power. That just now the DOJ has launched a lawsuit against Google. There is politics involved in that, but there is certainly a huge power of this platform. Some of my colleagues have said Amazon uses the ability to decide how to police, to help the clients that work more with them versus others, and what are the policy. There is not necessarily transparency. So you see, of course, all the problems. And so, a scholar, Ari Waldman, says fake news is a type of market failure. Is an example of falsehood rising to the top because of these information asymmetries that are between consumers and those running, the platform, and we need to trust the government to confront them. Now, Section 230, as I mentioned before, provides, because we want, again, to protect the marketplaces, because we think they are so important, they also can lobby very well in the United States. One has to be very honest and say, because of that, this provision says no provider or user of an interactive computer service shall be treated as the publisher or speaker of an information provided by another information content provider. And so, when we look at the first part of Section 230 and the second part of Section 230, there is almost an exclusive protection, a shield from liability for fake news by the internet service providers, specifically in this case, Facebook and others. And we know the information silos, we know the problem with politics, we know, and in the United States now we are seeing the investment and the control, what this platform do, how much the candidate for now president, but before, the Senate and all other political offices are using this platform, and how people just get news through the platform. They barely buy the newspaper or even just go to the newspaper website. And so you can understand easily the debate. And so, and Section 230 continues to be exactly as it is when it was adopted in 1996. So I'm not going to go through all the details of the case law. I'm happy to make the slides available to the public, whoever wants them. I'm very happy to distribute them. But already in 1997, there was the first case deciding, this was one of the leading cases by one of the Federal Court of Appeal, the Fourth Circuit, deciding the interpretation of Section 230. And here you have all the story of this case is called Zarin versus American Online. The reading of the shield against liability for intermediaries in this decision was very high, very wide. And that has continued to go along these lines for a long time. And these, we're talking about commercial news, but not only commercial news. We're just talking about liability for information. And so what, because from an intellectual property standpoint, and we're not talking about that in this specific moment here today in this panel, platforms are actually liable for infringement if they don't monitor and control and have knowledge or reason to know that an infringement activity is taking place in a specific, under their watch. Likewise, they are liable if they have control, a possibility, if they don't put in an act a sufficient control or enough means to trying to prevent this infringing activity. They can be found to be copyright infringement. They can be found to be trademark infringement. And this is, it can lead actually to even criminal sanction and criminal damages, not just civil damages in the United States, even statutory damages, which can be, of course, very high. But under the information, which is not intellectual property per se, unless we're looking into the world of trade secret, then we have a bit more vague definition and a higher shield for liability. And so advertisement in that sense is more considered an information unless there is a trademark or a copyright that is related to it. And so a bit more this laissez-faire approach has been the rule. But the reality, as I mentioned before, is that the difference between advertisement and information, between fake and real, between good and bad, it's very subjective, and the lines can be traced in a very gray area. There is a lot of gray space. So again, here you see that at the end of the day, the FTC has teeth, but not much. In the past, we were talking much more about misleading advertisement action. Now, much less. It also depends which government, to be honest, is in place, whether it is a more business-friendly or more consumer-friendly government. There is a lot of politics that goes, I think, in every country in this area. The remedies at the end are warning letters, sometimes sanctions, very rarely, unless there is really consumer fraud and consumer damages, and some actual, real danger, jail or some criminal sanction. And so because of that, we have seen a very relaxed approach or a non-tight enough until we have had, again, as I mentioned, there's the Bill of Rights, the freedom of expression, the First Amendment. They really are very tied into the American public for a lot of good reason. It's a principle that I very much subscribe to. Is a principle that informs transformative use in copyright. It's a very important principle. In Europe, we have freedom of expression as well. But there should be some limitation, particularly when the impact and the damage of fake news can be almost worse than the impact of freedom. So this capitalization on false information, even though they might not be intent to mislead, as Facebook has already said, but I'm not doing anything. I'm just a platform. I can check what a private group does. But there's been a certain breaking moments, and these were political breakout. We're not really commercial breakout. The 2016 presidential election, the Brexit phenomenon, this idea that we have foreign interference in national politics, not just in the US, but other countries have said the same. This Cambridge Analytica scandals. A lot of these have then brought more outcry and an understanding by the big platform that either they self-regulate or they will be regulated. And so you have seen a considerable amount of activity by the Facebook. And the other thing is the concentration. Facebook owns Instagram, Facebook owns WhatsApp and so others. And so it's not just, it's the advertisement and the news and all the channels through which the same consumers can get them through all the tools and the apps they are using. And I think one of the pivotal moments, in addition to, of course, the risk for politics, has then been COVID-19. COVID-19 I've seen I'm closing, yes. And I've seen a major rise in...
Cristina falou com a galera dela sobre passar o Natal em Vassouras. Ela disse, como lá é
Yes. And so COVID-19 have seen really a big rise in potential damages for people and risk for their health. And so we have seen an increase in action by the FDA for misleading advertisement. And that was a good news in the, that's really being a trend in the past few months in the United States. Because of the medical advertisement, the medical in the United States, the US is one of the few countries in the world where we can have advertisement for medicine, while in most countries you can't have advertisement for medicine. In the US, you can freely advertise in medicine and convince your doctor to get you that specific branded medication. Well, that is very dangerous in the COVID all the time, but in the COVID time has been amplified. And so we have started to see more action against misleading advertisement. And so the fake news in trade for that. And you can see just, by April 2020, the National Cybersecurity Center, this was the United Kingdom, for example, that removed more than 2,000 online scams. And so this is the US and, and so on. And, this is the Department of Justice memorandum in the United States. And for example, like doctor after COVID-19 treatment packs pay $4,000. And of course, we have had a lot of debate about hydroxychloroquine, whether it's good medicine or not. I don't want to mention who tried to push it, but you know, all these are certainly, you know, hot topics and very sensitive, and information are changing too. In fact, there were medical studies saying that hydroxychloroquine was a valid medicine, and then there's been denial of that information. And so it's really hard again here to see what's right, what's wrong, what's real, what's not, with the information changing. And so to conclude, and I hope, you know, very fast in the limited time I've given, is sufficient explanation, is in the United States, like everywhere in the world, we are seeing a lot of debate over fake news, with Section 230 of the Consumer Decency Act really zeroed in. Interestingly, the Republican and the Democrats both don't like it, because both want to have the platform, all political party wants to have the platform much more liable and basically not being able to say a lot of the things they do and be more on top of what they're doing. But in many ways, I think this is an old debate in a new platform, in a new place. And because of that is a dangerous, much more dangerous debate now, because it can really hit people faster on a much larger scale everywhere in the world. And that's why also, while we talk about comparative perspective, it would be nice to have some sort of synchronized way to deal with that, because what's fake news for country A will be fake news for country B and C and D. And so to have some sort of correlation in the responses would be possibly a good idea. I thank you very much. Muito obrigado.
Well done, Irene. You know, I appreciate your speech and your comments. You know, and I before I pass it to Philip Stromer, I just would like to highlight that I appreciate very much when you talk about the freedom of expression. That's one of the principles. You know, is in the American Constitution. You know, and that allows anyone to speak, you know, and about whatever they want. Of course, they have limits, you know, but this constitutional right is protected and also is respected in a sense, you know. And one thing that I would like to know, that it was nice to know, was that Section 230 is not specific for fake news. You know, it addresses, you know, relationship within the consumers or the consumers with business, which is really nice that you can extend interpretation and in a sense encompass, you know, fake news on trade, you know. So thank you very much. I'll pass it to Philip, and then at the end we have the questions, and maybe you can answer some of the inquiries. Thank you very much. Okay, we have now a new speaker, which is Philip Stromer. Philip is an attorney from Grönecker in Germany, and he's a litigator, you know, and also works with a lot with unfair competition, domain names, internet, and data protection. You know, Philip, you know, I appreciate very much you being here, especially because we were for almost, I think it was 2 or 3 years together at the INTA under the Unfair Competition Committee. And we had this big task of identifying modern unfair competition practices. And we were all surprised that we could find in the US, in Europe, in Germany, and also in Brazil, in China, you know, practices, you know, that were found online, you know, that were different from the ones that we used to see, you know, in the past, you know. So I pass the words to you, and welcome. Thank you.
Yeah, thanks so much, Jose, and thanks for the kind words. I remember back then we were working on the unfair competition matter that actually fake news were also a topic back then in your work. So yeah, thank you so much, Jose, for having me. Also ABPI for having me, and I'm happy to to speak on this panel today, and thanks also to my other co-speakers. Irene, thank you for your view on the topic. And yeah, fake news on commerce. As Jose said, I'm from Germany, so I want to give you the German perspective. And in this limited time frame, so let's jump right in. Maybe just one or two words to the law firm Grunecker. Jose mentioned it. So I believe right now in Europe, the largest sole IP law firm, a long-standing practice, as you can see, and for years now, top-tier firm in all the relevant journals. So fake news on commerce. What I tried to do when preparing for this day today was to start with a definition, right? So what I came up with is the idea of manipulatively distributed false or misleading information, which appear to be real news, mostly spread via social media, and then with the intention of damaging companies or their goods and services, and or influencing consumers in their purchasing decisions. The definition is important for our later look into the German law and the German perspective, and I've highlighted the most important key words here for your easy understanding and reference. So what can Germany provide in terms of laws against fake news? Two main focuses I want to put it on in this speech is the German Act against unfair competition and something that's unique German, that's the NetzDG, so that's a German word, a German abbreviation actually, but it's the law to improve law enforcement in social networks. And I want to point that out at the end of my speech. It's particularly important and quite cause for some debate here in Germany, as you can imagine, when you read the content. And of course, to give you the full picture, German European trademark law and German civil and criminal law as also effective basis against fake news. So the unfair competition in Germany is the most prominent and dominant basis for combating unfair competition. It regulates the market for the competitors. And in other jurisdictions, you often refer to it as market law or trade practice law. But at the end, and that's what it all comes down to here in Germany, so the practices should be in accordance with the maxim of good faith. So that's good morals and fairness. And also these two elements are important when further discussing this topic for the next 10 or 15 minutes. So, and I thought, you know, when speaking about what is fake news and why we're even discussing this in relation to unfair competition, so what is fair competition then? And I come up with three ideas that stand for fair competition, and that is truth, correctness, so statements must always be true and correct, clarity, they must be clear, unambiguous, completeness, and of course, incomplete information may be misleading, deceptive, i.e. false. And on the other side, what are the prohibitions under fair competition? So deception, as we all know, that's the other side of the medallion when talking about truth, commitment, misleading, as opposed to clarity, commitment, and the confusion that eventually will arise when misleading and deception takes place. And I think, Irene, you already mentioned it, and Jose also pointed it out, the freedom of expression, to express your opinion is, of course, always in conflict with the statement of facts and statement of fake news. And here in Germany, we make quite the differentiation when it comes to the legal enforcement. So statement of facts, as we all know, they can be proven or disproved, but opinions, they're not proof accessible. So these are personal statements, and by definition, they don't fall under fake news. However, if the basis of the expression of opinion are false facts, then it can be considered fake news. So, and you'll see as we move along, obviously it's not, none of this is easy. I don't want to put it too easy here, but it's a good starting point for the next couple of slides. So what the UWG, so the German Act Against Unfair Competition, comes up with as a general clause is unfair commercial practices shall be illegal. So the professional diligence is addressed here, and that is the morals and the fairness we just spoke about. And just recently, the German law incorporated 30 examples that more or less are fake news. Like you see here, the 2 bullet points. So the use of quality marks without the necessary authorization, false indication that certain goods or services are available. So if, and these examples goes to show you that the fake news are also a focal point in legislation here in Germany, as you will see later with the also famous law to improve the law enforcement in social media. And going forward, so we have the unfair competition that intends to protect not only consumers, obviously, but also competitors from discrediting them, denigrating them. And there is, again, freedom of speech comes in play. So even if the statement of fact would be true, it could be still discrediting. And then we'll have to talk about what are the legitimate interests for information of the public, the relevant public. Why do they have to know? Why do they want to know? And what is the legitimate reason for a statement made that is potentially discrediting for the competitors? And then if we're talking about facts that are not true, then it's more simple in terms of protection of competitors, even if they're, and even more so if they're harming. So as you can see, paragraph 4, number 2 provides a basis of legal claims for that as well. And just to give you an example, all of these, if we're talking about that somebody is pointing out in the first case that you're not able to supply certain goods after you advertised them and wanted to start the business, or on the other way around, somebody makes a negative, harming statement about your business. These are all fake news, and these federal Supreme Court decisions go back to 1993 and respectively 1997. So this has always been a huge issue here in Germany. And this is probably the misleading commercial practices. So this is probably the core when we're talking about fake news. So misleading commercial practices that would cause the consumer to make a decision that he would not have taken otherwise. So fake news ultimately lead to the confusion. It could be attributes of goods, reason for sale, components of tests, results of tests, sponsoring, and whatnot. So these are listed in the German Act Against Unfair Competition practices. Comparative advertising, as you know, that's a huge issue, maybe not as much as in the US, for example. So comparative advertising is allowed in Germany unless, you make a comparison that is not true, hence fake news. So relate to goods or services that are not for the same needs or purpose, relate to features or prices that are not objectively, or if you're trying to impair the reputation of a mark. So here, actually, both elements, the statement of facts and maybe the freedom of expression, and then which would lead to damage of a competitor, are all combined in this section here. And this is an overview of claims. Just to give you a rough idea, all of these claims, I spoke about the civil law and the well-known trademarks and whatnot. And one major advantage here in Germany is obviously we have the cease and desist, claims elimination, damages, cost reimbursement, but we can rather effectively enforce them. So by way of an inter-party preliminary injunction, we might have a decision in a couple of days. We have now an issue actually with fake news, where we send a cease and desist letter up front, and no surprise, we didn't receive a cease and desist declaration. And then we went to court and we got the decision 3 days afterwards. And this is the main advantage here in Germany, and probably why this topic is so controversial here as well. We can force somebody within a couple of days upon service of a preliminary injunction to immediately stop that. Even if he appeals the decision, then we would, that it has no suspension effect, so it would still have to follow the decision. And now the NetzDG, so as I said, the law to improve law enforcement in social networks, or as also referred to here in Germany, the Facebook Act. So this is applicable for social networks with more than 2 million members, and it aimed inter alia to combat hate speech and fake news. So once the social media platform gets awareness of a possible infringement, and after examination, it has an obligation to remove and block the illegal content, and has even reporting obligations, and it has to establish and prove a complaint management system that actually works, because as you can see, with obvious infringement, and that meaning infringement that cannot be seen any other way, even if it goes to court, even through the instances, the likelihood that a decision would get overturned has to be minimal. And those obvious infringement must be deleted within 24 hours, others in 7 days. So as you can see, there's a bit of a conflict here, and I addressed it in the last point, the major point of criticism here. Again, freedom of speech, and this Facebook Act, where it should, I mean, obviously, people are living in their own reality, and they were, and with people feeding off of social media, they try to build on that even more so with the likings. But ultimately, and at least that's what the critics say, it should be the responsibility of the state of Germany to address what should be removed online and whatnot. And it should be not to the discretion of Facebook or any other social media channel and platform to decide what would be removed and what not. And this is actually one major criticism. The NetzDG, so this act is in force since 2017. And a lot of discussion, as you can imagine, and actually some new developments have come in now, but to the contrary of what you would expect, the controversial discussion and the outcome of it, there are tendencies that the obligations for social media networks will be tightened up, and also to facilitate the process of deleting statements. So that is in discussion, and that's a huge thing here in Germany as of now. And so we were talking about legal deficiencies, or we wanted to address those. And as I said, we in Germany, we believe we have many legal tools against fake news, and which are very effective, very quick. And in particular, the unfair competition law here provides a full range of motion, however, only for competitors. So if you're not addressing the same clientele, if you're not within a certain chain of suppliers, say the automotive industry, so BMW and its suppliers, those are competitors in that sense. But if you cannot enjoy the provisions that the unfair competition claims provide. then you have to recur to civil law or criminal law even. And then it's not that effective and not that clear, actually. So this is maybe a deficiency when it comes to German law. And also, like I said, and I think we will address this a couple of times, has been addressed already by Irene and will be. And people are always quick to say this is freedom of speech, but again, there is a danger. That's a given, and we should be very aware when we to identify fake news or what's irrelevant and what can be deleted. But at the end, and that's maybe it's not that simple. But as I made it in the beginning, but if you have a factual statement that can be proven wrong, then it has nothing to do with freedom of speech per se. And the freedom of speech, if it's not damaging anybody, then it always should prevail. So that's it for me. Thank you so much for your attention. I'm looking forward to having your questions, and also I know we have limited time, and I think I stayed right under 20 minutes. So please feel free, everybody, to just send me an email. I'm happy to answer any questions you might have, any inquiries, even after this session tomorrow or the next days. Thank you so much.
Thank you very much, Philip. Excellent. You know, and it's funny because you and Irene touched in a very important point, that's free of expression, and about the, in a sense, contradictions and balances and balances of that, you know, what should, when examining the damages and also the practice of fake news, you know, the free of expression should take into consideration for that. Very good. And also what I like the most is like when we learned when we were in law school was that the Germans, you have an Unfair Competition Act that in Brazil we do not have it, as we have we use it general principles, you know, based on that came from the illicit acts or illicit practices from the French civil code, you know. So it's what I like the most on your presentation is that you attempt, in a sense, to frame fake news under your German Act. So congratulations, really well done, you know, really well done. Well, you know what, and the important point here is that we have learned, I have learned 2 years ago that we have a Chinese, you know, specific law on unfair competition that addresses, you know, trades on online platform. So for this purpose, I have invited Mei Li. You know, Mei Li is from Shanghai. Mei Li, you know, like your curriculum here is in Portuguese, so I'm going to read in Portuguese, you know, because first of all, it's extensive. It's like Irene, you know, like the full page, you know, because you are also a professor. So I'm going to read only one paragraph of your currículo em português. So, o senhor Mei Li obteve o seu PhD em Direito em 2010 na Escola de Direito da Universidade de Jilin, uma das principais escolas de direito da China. Ele agora é professor associado na Universidade de Ciência Política e Direito do Leste da China, especializado em propriedade intelectual e direito econômico. And Mei Li was also designated as a assistant judge in the IP Tribunal of the Tribunal Popular of Pudong New District in Shanghai, China, within the period of 2013 and 2014. You know, thank you very much, Mei Li. What's the time there? You know, I think it's 3 o'clock, should be 3 o'clock already, yeah? Thank you for your participation. You have the words.
Oh, thank you very much. Can you hear me very clearly?
No, you know, we cannot hear you properly.
Can you hear me?
Yes.
Okay. Perfect. Well, thank you so much, Jose, for your kind words. Although I don't understand much of the content of your introduction, but I think they're good words, right? And hello there. I hope you are doing fine. And I'm here in Shanghai to say good morning to you, because it is the early morning here in Shanghai. And my name is Ma Le. I'm from East China University of Political Science and Law, teaching and doing research on IP law and trade law. I'm very happy to be here. Before I start, I would like to give my special thanks to Professor Irene Carboli to engage me in this amazing conference and to connect me with the amazing co-speakers. And I believe that I will learn a lot from this panel discussion. And today I'm going to talk about the regulation of false publicity in the digital platform under Chinese law. Actually, like the previous two speakers said, fake news in Chinese law is not exactly a terminology in the statutes or articles or the rules. And just as Jose mentioned, because China just amended its anti-unfair competition law, including the articles or statutes concerning fake news. So I used the terminology in that law, which is false publicity, to address this issue. I hope I can pass in accurate information in terms of the articles or laws to the audience. And in today's talk, I would like to mention three main aspects. The first one is the legal framework to address the issue of false publicity in Chinese law. The second one is mainly about the introduction of amendment of anti-unfair competition law in China, which happened just recently. And the third one is about the enforcement of these legal rules, as well as the liability which was caused by breaching these rules. In terms of the legal framework, we all know that in the international law level, specifically the Paris Convention for the Protection of Industrial Property, it actually stipulates the unfair competition in terms of the, we may say fake news or false publicity in the specific legal rules. It uses false allegations or mislead the public to describe this kind of behavior. In line with the rules or statutes of the Paris Convention, actually China also put this issue mainly in the anti-unfair competition law. So in today's speech, I will mainly address the anti-unfair competition law and its relevant rules. But we have to keep in mind that in China, actually, not only AUCL is the legal basis to regulate the false publicity. In the recent years, China did issue some laws or amend some laws to address this issue, which are the relevant laws I'm going to mention in today's speech. Here I just displayed three main laws, which I think would be the legal basis with the AUCL to address this issue in China. One is the e-commerce law, which was enacted in 2018. And the other one is advertising law, which was amended in the same year. And also the law on the protection of consumer rights and interests before these two laws, as well as the amendment of AUCL. In addition to these relevant laws, China also had a specific departmental rule, which was called administrative measures for online trading, which was issued by the State Administration for Market Regulation. Actually, this rule was enacted in 2014, emphasizing a lot about the online trading issues or problems, including the false publicity, which happened online. And from the timeline, I just would like to mention some keywords from the laws which I mentioned, starting from the law on the protection of consumer rights and interests. Actually, in this law, the consumers are entitled to ask for compensation for the infringement when engaging in the online transactions or consumptions. So here you can see actually this law has already addressed the issue concerning the information review and false or misleading promotion. And also it sets specific liability for the online business operators as well as the online trading platforms. Especially if the online trading platform does not, bear the obligation for the supervision or, control of the misbehaviors of the business operators in its platform, it should be jointly and severally liable for the infringement of the consumer or the competitors of the online business operators. And the AMOT, which I mentioned, actually, you can see here, it specified some behaviors or acts which would constitute the false publicity, like fabricating transactions, deleting unfavorable evaluations. And also it has an unlimited article to include or to be inclusive for more possible behaviors or acts which can consist of the false publicity. And the AUCL, actually, Jose just mentioned that China amended this important law, which was firstly enacted in 1993. So after 24 years, this law welcomed its first amendment. And among all the changes from the old law, the regulation of the false publicity actually was mentioned a lot. Here you can see this article actually is the key rule to regulate the false publicity in China nowadays in terms of regulating the fake news behavior or fake news phenomenon. It not only include the false or misleading commercial publicity and specify the false or misleading commercial publicity, but also it mentioned a very important clause, which is to regulate the helpers, those who help to constitute the false or misleading commercial publicity by organizing false transactions or any other means. So later I will share a case with you about the punishment or a penalty for this kind of behavior. And in addition to Article 8 concerning the false publicity, also this law was highlighted by the Article 12. Article 12 actually compared to the 1993 AUCL is a totally new rule because it specifically addressed the online environment in the AUCL. So you can say a business engaging in production or distribution activities online should abide by the provisions of this law. And in the specific circumstances, it mentioned misleading, defrauding, which are concerned with false publicity. And e-commerce law, actually e-commerce law could be a special law or specific law addressing the legal issues concerning e-commerce. And in this law, according to Article 17, it also tries to regulate the false publicity. But in its legal liability section, it actually clarified the relationship between this law and the AUCL, because it says that if someone commits the relevant behaviors like misleading consumers or making false information, it should be punished according to the relevant laws. Here, the relevant laws concerning the false publicity actually means the AUCL. So this law actually tries to give a clear, coordination between itself and the AUCL. And advertising law, actually, advertising law also is very, related to the fake news or false publicity. But usually, when we see false publicity in the Chinese law context, we are addressing a general false publicity. If this kind of publicity consists of or constitute the advertisement, okay, it will go to the advertising law. So in the advertising law, it also, you can say, it addressed the regulation of false advertisement. So to draw a very quick conclusion for the first aspect, we can say AUCL 2017 could be a milestone to address this issue in terms of the legislation in China. Before that, China actually regulates this kind of behavior, including the behavior in digital platform, mainly based on the AUCL 1993 and law on the protection of consumer rights and interests, and the administrative measures for online trading. So these actually consists of the legal system to address this issue. And when AUCL 2017 was issued, actually, it becomes clearer because in this law, there's a specific article addressing this issue, and it clarifies the general false publicity and the false advertisement. If the false publicity, as I said, consists of advertisement, we're gonna use advertising law to regulate. So after that, we can see now we have AUCL 2017, e-commerce law and advertising law to address the fake news issues. Okay, the second aspect is about amendment of AUCL. Here I just make some comparisons between the old law and the new law. Actually, China amended the AUCL in 2017, and after 2 years, China again amended the AUCL. And why it is so close? The time is so short between the two amendments. The 2019 AUCL actually is mainly about the changes of the trade secret articles or clauses. And in relation to the false publicity, actually, these two laws actually share the same characteristics. I mean, the article is the same for the 2017 and 2019 concerning the false publicity. And here, when we compare the two laws, 1993 and 2017, we can actually generalize some clues. Firstly, it becomes clearer to address this issue in the AUCL. If you look at the old law, you find that, okay, it puts both the false publicity from the general sense and the false advertisement in the same law. And for the new law, it only addresses the general false publicity. And actually, it gives the regulation of false advertisement to the advertising law. So it becomes, I think, clearer to clarify these two things. And as I said, in the new law, actually, you can see it specifically emphasized the regulation of business which helps another business conduct any false or misleading commercial publicity by organizing false transactions. So later, I will address more about false transactions regulation. And in terms of civil liability in the AUCL, actually, the old law and the new law are basically similar. The business which or who was damaged by the false publicity can ask for compensation from the doer of the bad behavior. And also, the compensation can be carried out by either the profits earned by the tortfeasor or the loss incurred by the victim. And another very obvious difference is about the admin liability, administrative liability. And in the old law, it also mentioned that the supervision agency can penalize the behavior by imposing fine. And here it gave a specific number of the fine, not less than 10,000 yuan, no more than 200,000 yuan. But in the new law, actually, it lifted the level of the fine. You can say from general sense, it should be not less than 200,000 yuan, no more than 1 million yuan. If the behavior is very serious, it could be, as high as 2 million yuan. I think that is very important, a strong sign for the commerce or the business that, okay, if you commit such kind of behavior, you could be very seriously punished. And also here, it mentioned that if that behavior consists of false advertisement, it will be regulated or punished according to advertising law. And in the advertising law, it has the same, the same punishing or penalizing articles as in the AUCL. Actually, these two things could be, coordinated. And the criminal liability, actually, in the old law, it mentioned criminal liability, but it specified the behavior as including fake or inferior commodities and bribery. It does not specifically mention the criminal liability for the false publicity. In the new law, it actually introduced a general article, which are Article 27 and Article 31. You can see that, okay, according to these two articles, all kinds of anti-competitive acts could be criminally punished according to this law. It also gives a very strong sign to the business that, okay, be careful, your behavior might be criminally punished according to the criminal law of China. So if we just draw a quick conclusion for the second aspect, we can see the false publicity in China's legal system, can, according to AUCL, can generally characterized into three, dimensions. The false publicity could be fake publicity or misleading publicity. If the fake or misleading publicity is in a general sense, it does not consist of advertisement, okay, it would be regulated mainly by the AUCL, and it can trigger the civil, admin, or criminal liabilities. If they could be considered as advertisement, okay, go to advertising law. Again, they would be punished both civilly, administratively, or criminally. And if you have, other businesses or business operators to, commit the false publicity, and you will be also be punished according to the civil, admin, or criminal liability articles. Then I would like to share two cases with you. The first one is actually happened just after the amendment of the AUCL in 2019. It was between Taobao, which could be one of the biggest online trading platforms affiliated to Alibaba in China, versus Meiming, another company. In this case, actually, Meiming company, the defendant, set up an online platform. You can see here, meilipa.com. This actually online platform is to help the business operators on the Taobao, which is an online platform, to promote their commodities. Okay, if you want to, promote your commodities, you can register as the member in the Meilipa, owned by the Meiming company, and the Meiming company will help you to promote your commodities. How? It actually uses a way for trying out, which means, okay, as a consumer, you will be free to try out some kinds of products on this platform sold by these members. But when you buy these things, you will not get the things you buy for free. Actually, you get another commodity for free. That commodity actually is maybe much cheaper or not that valuable. then you get refund of buying the first product from the Meiming company. And that is actually considered as a false publicity by the court. The court thinks, okay, Meiming company actually is doing something which is considered as false publicity. And then it has to give the compensation for 2 million RMB to the plaintiff. And in this actually case, it also mentioned the judicial interpretation, which specified some circumstances to understand the false publicity. So here I just I give the statutes for your consideration. And according to this judicial interpretation, we're going to have more specific standards to judge whether this is false publicity or not. Another case is about also about fabricating transactions. In this case, the accused set up a platform to run the fabricating transactions from 2013. This guy just hired a lot of fake buyers to make complete transactions for the members. The members also the business operators from Taobao platform. And the accused just collects membership fees and deposits from these members. And then, he was sentenced for 5.5 years imprisonment with a lot of fines. This case actually gives a very strong signal to the market that, okay, if you commit the fabricating transactions, you're going to be criminally punished by the criminal law. And a crime is a crime of illegal operation, according to the Article 225 of the criminal law. But some people also say that, okay, China should fix a specific crime which pertains to the fake publicity. And I think in the future, maybe with the development of the online trading or the e-commerce, there could be some specific more accurate crimes to address this issue from the criminal law sense. So lastly, I would like to draw the conclusion. Firstly, actually Chinese law, not only the AUCL, but also some relevant laws has already recognized the importance to regulate the false publicity in the digital platform. And the AUCL tries to coordinate the relationship among different or relevant laws. And in the next step, I think the implementation is the most important thing for China, both from the civil aspect and the administrative aspect. Okay, I think I have already run out of my time, and I would like to thank you again for your attention. And if you have any other questions, please send me emails or let me know. Thank you very much.
Thank you, Mali. Thank you very much. I really appreciate your talk. And explaining about if I can consider your new Chinese code on anti-unfair competition is not new because it's a development of the one in 1993. But thank you very much for sharing that. I have pointed out some issues really interesting addressed by you, especially one considering false and misleading commercial publicity, which are completely different. That can also lead to fake news, depending on the complexity of the issue. But let's leave it, this discussion possibly by the end, if we have some time. Now I pass the words to Raul Murat from Brazil. Now Raul he obtained a PhD from the State University of Rio de Janeiro, where I teach. And also he's a professor of the Catholic University here in Rio de Janeiro. And also a member, associate member of the Denis Barbosa attorneys, and which is renowned, especially the name of Denis attorney, which for me, after Gama Cerqueira, is the most prominent law developer and that discussed a lot, and a scholar, that's the word, the scholar on IP law, Raul, with the words, and, lead it, please.
Hello, guys. Good afternoon. Good morning to Meili and Irene. Mali, sorry. I'd like to thank José Carlos for the invitation. I'm going to speak in English because José Carlos asked me to speak in English to avoid the simultaneous translation. So I'm going to try to address the same problem related to unfair competition and fake news related to the Brazilian framework. So let me just show the PowerPoint to you. Okay, can you see it? Yeah? Yeah?
Yes, go ahead.
Okay. Yes. Okay. So as you guys will see, I'm not that developed or I don't have the expertise developing a PowerPoint presentation. I'm not very good at it. I'm good at some kind of using boards and charts and stuff like that. So you see that my PowerPoint presentation has just 3 parts, So I took my PowerPoint presentation and made a board with it. And the main issue that I will address, I will talk about, is if there are some legal deficiencies in the Brazilian legal framework related to unfair competition and fake news. And firstly, I'd like to clarify that my presentation will have a narrow scope. I would not talk about the consumer legal consumer framework, and I would not talk about the antitrust framework, and I would not talk about the political framework related to fake news. I'm only going to talk about the legal framework related to unfair competition whenever we have 2 private agents dealing with each other in the same competition context. And I don't intend to present a specification related to what I intend would be fake news. I think my colleagues have made a very good clarification about what could be fake news. And as we know, fake news could be a very good range of activities. So we have fake news that is related to a false information, but we have another specifications related to a very peculiar use of an information that's not really fake, but it omits some kind of information and it could present a misleading interpretation of the reality. And all of them could be presented and could be understood as fake news. And I think that all of them are part of this presentation. So as Irene have told, we are in a situation when we have a node dilemma that nowadays presents a huge problem because of the digital platforms. It expands not gradually, but in a very agile way. I'm sorry, guys. I'm a little bit nervous. There's some time that I haven't spoken English for a huge crowd. I apologize for my poor English. So there was this this study from the MIT from 2018. And the study from the MIT from 2018 has shown that fake news on Twitter spreads 5 times faster than truth news or than news that are not fake. And this study was conducted for 10 years. It took stories that traveled through the Twitter network during 10 years, and it have analyzed and it has presented that people were sharing about the same story 5 times more information that were fake than information that was not fake. And the study was fantastic because despite that, the study has analyzed why people were sharing information that was fake much more than information that weren't fake. And it understood that, and it concluded that most of the times when people see some information that is not fake, or most of the time this information that is related to fake news, this information is made in some way that trigger a reaction from us, from distrust, from disgust, a reaction that we get really mad, and we want to share it and show to the world why we are really mad. And whenever we see some information that is not presented in this way, most of the time we just see the information. Some of the time we want to share it with some people, but it's not in the same way as fake news are presented. So this fake news dilemma is a major dilemma nowadays, because the way people share this information, especially and not only in the political area, but in trade, but in commerce. And so most of the times, because of this, people are thinking that we don't have a legal framework that could deal with this problem. And people think that we have to modify our legal framework. We have to present some solutions that are harsher, some solutions that could protect the plaintiff in a faster way, and that our legal framework nowadays is not sufficient, it's not enough. So my presentation now is to analyze and to see with you guys if our legal framework, the Brazilian framework, is enough, is sufficient to deal with this problem. The first thing is, has it been analyzed by the Brazilian courts? In 2018, I believe there was it has been said at the news that this was the first case related to fake news and digital platforms that was analyzed in the Brazilian court. It was analyzed at the Brazilian court, the State Court of São Paulo. It was a lawsuit that PSafe was the plaintiff and Baidu was the defendant. PSafe was arguing that Baidu was spreading false information in the cell phones that its consumers had in Baidu app installed. And this false information was that whenever a person or a consumer had in its phone and Baidu app and the PSafe app, the Baidu app would trigger an information that the PSafe app was some kind of virus. And so PSafe has filed this lawsuit showing that PSafe was not some kind of virus. Actually, PSafe was an app related to the protection of the data at the telephone, and PSafe was showing that the Baidu app could permit a breach of data. And then it was shown before the court, and the State Court of São Paulo condemned Baidu as its defendant because there was strong technical proof that the PSafe app was not a virus and that the Baidu app was actually an app that could provide a breach of data. And so it was presented that the information that Baidu was spreading was a false information, was fake news. So as we can see at the Brazilian court, this is some kind of new situation at the Brazilian court, but it isn't that new. It's new if we see that the court has analyzed and case related to unfair competition and digital platform. But it's interesting that when we read the vote of the judge specifically says that the court have been analyzed a lot of cases related to unfair competition and false information. Not most of them in the digital platform, but some of them related to the digital platforms, and some of them that had the same consequences that the PSafe app and Baidu app case had when they were presented at the digital platform. So this is new, but it's not that new in the Brazilian courts. Before we analyze our present framework, I'd like to show you that we have some discussion in our legislative chambers related to some proposal of bills that could address this matter. We have the commercial code proposal of bill, and the commercial code it's not related to fake news and digital platform. It's not related to unfair competition and digital platform. It's section 130. Only has until now some provisions related to unfair competition. Actually, and most of the time, the proposal of the commercial code uses the same language that we have in our IP law that has some parts related to unfair competition. So it's not that relevant for the discussion now. And we have the fake news proposal bill. The fake news proposal bill, as the name says, it's a bill related to try to provide more transparency, to try to prohibit inauthentic accounts related to digital platforms. It's a bill that tries to bring more responsibility to the digital platforms. It could be a bill that has some interference related to the unfair competition and the digital platforms, but it's not a bill related specifically to unfair competition. This bill was made especially to the political status, to the political scenario, and not for the commercial scenario. So sections 6 and sections 12, they have these provisions related to inauthentic accounts and the responsibility of the digital platforms, but they are not specifically directed to the commercial scenario. Sorry, there was a bug here. And how is our legal framework? So in our legal framework, I'd like to address the problem in 4 ways. So does our legal framework stands, or does the Brazilian legal framework has some provision that would allow a partner to file a lawsuit against another partner that has practiced fake news? So this is the first question. The second question, does our legal Brazilian, I made some stuff here. I clicked at the chat, and okay, Jose Carlos has sent me an information, and then it appeared. So does the Brazilian legal framework allows for a preliminary injunction in this aspect? And so the Brazilian legal framework has a burden of proof that could help people in the discussion related to unfair competition and fake news, and the same for damages. As you can see, according to my interpretation, the Brazilian legal framework addressed this problem, not specifically to digital platform, but address the problem related to unfair competition. In the IP law, we have these provisions specifically that stands that if some agent or if some competitor present, publish, or publicize some false information or some misleading information against a third party, it could be understood as unfair competition. So we can use these provisions and apply it to the digital platform scenario. And some could argue that the IP law has a final clause in the unfair competition that established that it would be unfair competition only if the false information was specifically to gain an advantage against the third party. Yeah, it has this final clause, but in the civil code, we have the provision 187 related to abuse of rights. And this provision related to abuse of rights could be used to prevent unfair competition in the digital platform. So the Brazilian legal framework in this aspect, it's okay. In the preliminary injunction, specifically the IP law and the Internet Bill of Rights law and the Brazilian Civil Procedure Code, all of them, they have provisions that allow a judge to grant a preliminary injunction if there is some minimal proof of unfair competition and in digital platforms. I have made the research at the State Court of São Paulo for the past 5 years, and I've used the expressions unfair competition, tarnishment, and preliminary injunction. I found 15 cases that were ruled by this court at the past 15 years, and 6 of them, they weren't relevant to this presentation because they had some peculiarities. So we had 9 of them. In 9 of them, in 6 of them, the court has granted a preliminary injunction. In 3 of them, the court has not granted the preliminary injunction. So we can see that not only technically, but in a pragmatic way, and seeing what our court has been deciding, there is the possibility of a preliminary injunction in unfair competition in the digital platforms. And not only in the digital platforms, but in unfair competition related to fake news. There was this lawsuit really interesting between 2 companies that sells mayo, mayo that you put in the bread and hamburger and stuff like that. And one company had this publicity at the digital platforms saying that its mayo was tastier, creamier, and smoother than the other mayo. And it was saying too that its mayo had the approval of 80% of the consumers. And so the court had analyzed this information, and at the first information that the mayo was tastier, smoother, and creamier than the other mayo, it was interesting because the court understood that tastier is something subjective, and there is no fake news related to that. An agent can just make an advertising saying this, and it will not represent, it will not mislead the consumer. But the presentation related to smoother and creamier, the court understood that this was a technical issue, and the defendant had some proof that its mayo was smoother and creamier, and then understood that there wasn't any kind of fake news. And related to the fact that 80% of the public would prefer this mayo, the court understood that there was some kind of fake news because there was no proof, there was no research, specific research, a methodological research that could prove this kind of understanding. And so that the legal framework is good related to this problem too. According to the burden of proof, in fact, we could have some problems related to the burden of proof. There are some situations in which the plaintiff does not have the possibility to prove entirely that that information is a fake news because they are really peculiar, they are really elaborate, but our civil procedural code has this provision that allows that the judge may have a dynamic vision of the burden of proof. So if the judge believes that some of the parts could not easily bring the proof, or if the judge believes that the other part could easily bring the proof, the judge may alter the burden of proof and establish that the defendant might show that the news is not fake, but the news is actually good news. And it happened at the State Court of São Paulo in the same way. There was a case, a very interesting case, in which there was this distributor. He was presenting himself as an official distributor of some products. And whenever people approach him, the consumer approach him to buy the products, he always said, oh no, at the present moment, I don't have the product, but I have another generic product. If you want to buy a generic product, I can sell it to you. And so the court believed that this was fake news because, firstly, he wasn't an official distributor of the first product. And secondly, he never, not being an official distributor and not being an official distributor, he never sold the other product. He was always doing this advertising, this fake advertising, to approach the people and to, in a fraudulent way, arrange the consumers related to the other competitor. And at the end, we have a very, very, very good and very strong legal framework related to damages and related to another ways to prevent unfair competition, or to punish unfair competition, or to compensate the part that's violated. My time is ending. And since just one moment, since 1994, we have this in our courts, this right to retract, this right to disclaim, this right to present a news that's not fake news. It happened. Leonel Brizola was a very famous political figure in Brazil, and TV Globo has published an editorial saying that he was crazy and he was not a good political figure, and then just saying stuff like that. And then he got this right to oblige, to establish that Globo had to read his statement in the national network, showing that what Globo said was fake news, and it didn't have any kind of objective statement, and that Globo was wrong. So we had this kind of stuff, and we still have it. And the legal framework allows to subsidize the fake news if in a lawsuit the judge established that the defendant have to publish several times the news claiming that the other news are fake. So again, with the same question, the fake news dilemma, is it enough? Is the Brazilian framework enough? Actually, the Brazilian framework is enough. I believe so. Whenever we are dealing with the situation between two economic agents, two individuals, two private agents, we can't forget that our Supreme Court a few years ago, when it was judging about the possibility of having an unauthorized biography, it had understood that freedom of speech is a constitutional right that cannot be banned, cannot be mitigated. And so it's better to use the legal framework that we already have than present, or then try to present another legal framework that's harsher and that could prevent or impede the exercise or the freedom of speech. Thank you for your patience. You are mute. You are mute.
Yeah, sorry. So again, thank you very much for your talk. I appreciated that you gave an overall legal framework on fake news and unfair competition, and also you answered the question that we presented. That was the topic for our table topic. There is, I think we have passed already 16 minutes. Carolina said that maybe we could have one question. So if I ask if anyone from the audience wants to present a question or to present a question to the participants. I cannot see anything on the chat. If not, we should end.
José Carlos. José Carlos.
Yes. Oh, Valdir. Yes.
Hi.
Yes.
Good morning. Good evening to everybody. Thank you for the presentation. Very good. Thank you, José Carlos, for moderating. My name is Valdir Rocha. I'm the director of ABPI. And I have a question to our Chinese speaker, Ma Le, about the interference of the Chinese state on the platforms regarding fake news and false advertising. Do you have any self-regulation system or the companies that are affected by false advertising have to sue the other party, or you also have the intervention of the state? Because here in the West, we hear that the Chinese government has control of platforms, which is different from here. You have the equivalent of eBay, the equivalent of WhatsApp, and so on. You have social networks like TikTok and Quai, etc. So my question is whether you have self-regulation, whether companies have to go to the judiciary, and whether you have state intervention in platforms because of fake news or false advertising. Thank you.
Thank you.
Well, thank you for your question. If I'm correct to understand your question, I think you're asking that facing up to the fake news, whether there are two kinds of interference or regulation. One is the self-regulation by the platform itself. Another one is from the government interference, right?
Yeah, yes. Whether there is self-regulation, not only by the platforms, but by a body, as we have here in Brazil and in most of the South American countries, we have CONAR, which is the Self-Regulation Council for Advertising. So my question is whether you have self-regulation for false advertising and fake news, and whether there is government intervention, interference in the platforms.
Okay. Well, firstly, since for these topic, I mainly focused on the, the government interference from the perspective of the regulation or the law of China. And so it's very clear that we have the law in place, not only the law made by the National People's Congress, but also the regulation made by the State Council and the lower level departmental rules by the, administration, state administration for market regulation. So we have different levels of laws enforced by the government to guarantee that the false publicity in the digital platform could be effectively regulated. And for the self-regulation, firstly, I have to apologize. I didn't research too much from that perspective, but to my limited knowledge, I think, yes, there is. For example, when I mentioned the law on the protection of consumer rights and interests, I know that we have a specific association, the Consumer Association. Consumer Protection Association. Actually, it plays a very important role in terms of the protection of consumer rights and interests. It also has its own self-regulation rules to regulate, the market order, all the things, the behaviors made by the business operators, which can damage the rights and the interests of consumers. And for these platforms, well, maybe I can do further research to say whether there's specific the association for the platforms. But so far, I think there is, but I don't know the specific name and how they function to, implement the self-regulation.
Thank you very much.
Thank you.
Okay, thank you, Valdir. I think we should end now because I think it's almost, we passed almost 13 minutes, I don't know if you're allowed to, Valdir, from the direction of the ABPI, if we should allow another question, but yeah, but I think we should move on, because we have already passed 20 minutes. And thank you very much for Bailey and Irene. Good morning for you, yes. And, I mean, you are 11 hours ahead. And Philip, thank you very much too for your participation. Raul, thank you a lot for the overview on fake news and unfair competition in Brazil. And thank you, Valdir, and all the participants for the opportunity, okay? Thank you. Bye-bye.
Bye.
Bye-bye.
Thank you. Bye. Thank you.
Congratulations.
Bye-bye. Thank you.
Bye-bye.
Thank you.
Thank you, Meili. Irene, Philip, Raul, thank you.
Bye-bye.
Thank you so much.
Thank you,
Bye-bye.
Jose, for organizing and doing everything. Too.
Yes, thank you.
Yeah,
Thank you very much, Jose.
Bye-bye.
Yeah.
Great, Jose.
Thank you, guys.
Bye.
It was nice meeting you.
Bye, Raul.
Yeah. Bye. Bye-bye.
Bye, Irene. Bye, Ma.